Ready, start. The question for our consideration is whether the High Court could have justifiably invoked judicial review under Article 226 of the Constitution to interdict personal insolvency proceedings initiated against respondent number 1 under Section 95 of the Insolvency and Bankruptcy Code, 2016 by holding that his liability as a debtor has been waived. Full stop. The High Court jurisdiction was invoked against the order of the adjudicating authority dated 16/2/2024 appointing a resolution professional and directing him to examine the application under Section 95 and file a report under Section 99 of the IBC. Full stop. Having considered the facts, we set aside the judgment and order passed by the High Court and restore the proceedings before the adjudicatory authority from the time of its order dated 16/2/2024 directing the resolution professional to submit a report as provided under Section 99 of the IBC. Full stop. The relevant facts are that respondent number 1 was a promoter and director of One Associate Decker Limited. Full stop. While corporate insolvency resolution proceeding has been initiated against the corporate debtor as well, this is not the subject matter of the present appeal, which is restricted to the personal insolvency proceedings against respondent number 1. Full stop. Commencing from 2010, the corporate debtor took various loans from the appellant and respondent numbers 3 and 4, who are a consortium of banks. Full stop. Respondent number 1 entered into a deed of guarantee for securing these loans on 10/7/2014. Full stop. Due to default in payments by the corporate debtor, and after initiation of CIRP against it, the appellant issued a demand notice dated 11/8/2020 and invoked the deed of personal guarantee, calling upon respondent number 1 and other guarantors to pay an amount of rupees 244 crores. Full stop. However, by later dated 14/12/2020, respondent number 1 and other guarantors offered rupees 25 crores as full and final settlement. Full stop. After issuing a demand notice in Form B under Rule 7 of the Insolvency and Bankruptcy application to adjudicating authority for insolvency resolution process for personal guarantors to corporate debtors rules, 2019 on 22/2021, the appellant filed an application under Section 95 (1) of the IBC read with Rule 7 of the rules to initiate personal insolvency proceedings against respondent number 1. Full stop. The adjudicating authority, by order dated 16/2/2024, appointed a resolution professional and directed him to examine the application and submit his report as provided in Section 99 of the IBC for approval or rejection of the application. Full stop. On objections raised by respondent number 1 on limitation and the validity and existence of the personal guarantee, the adjudicating authority, relying on the judgment of this court in Dilip B. Geo Rajka versus Union of India, stated that the issues/objections raised by the learned counsel for the personal guarantor will be considered after the submission of the report by the resolution professional and response of the personal guarantor on the same. Full stop. Respondent number 1 preferred a writ petition before the High Court under Article 226 of the Constitution to prohibit the adjudicating authority from entertaining the personal insolvency petition against him, primarily on the ground that his liability as a personal guarantor stood waived and discharged. Full stop. The High Court, while the order impugned before us, allowed the writ petition and held that the personal insolvency proceedings are not maintainable as respondent number 1's liability as a guarantor had stood waived. Full stop. In order to arrive at this finding, the High Court examined various documents pertaining to the guarantee and the loans. Full stop. It further held that this court in Geo Rajka Supra was not considering an application that was not maintainable before the adjudicating authority, and thereby distinguished the same. Full stop. Pursuant to the impugned order passed by the High Court, the adjudicating authority disposed of the insolvency proceedings against respondent number 1 by order dated 19/6/2024. Full stop. We have heard learned Solicitor General for the appellant and learned Senior Counsel for respondent number 1 in detail full stop. The simple question for our consideration is whether the High Court correctly exercised its jurisdiction to interdict the personal insolvency proceedings under the IBC against respondent number 1, full stop. It is necessary to appreciate the statutory scheme regarding the admission of an application for initiating personal insolvency under Part 3rd, Chapter 3rd of the IBC, full stop. This court in Jiu Rajka within bracket Supra, while deciding the constitutional validity of sections 95 to 100, has delved into the same and has held as follows. Full stop. Pursuant to an application for initiating personal insolvency proceedings under Section 94 or Section 95, the adjudicating authority appoints a resolution professional under Section 97. Full stop. The resolution professional performs distinct functions under Part 2nd within bracket dealing with corporate insolvencies bracket close and Part 3rd within bracket dealing with personal insolvencies bracket close of the IBC, full stop. Under Part 3rd, Chapter 3rd, the resolution professional performs a facilitative role of collating information, as provided under Section 99 of the IBC, in which the resolution professional examines the application, determines whether the debt has been repaid, and submits a report to the adjudicating authority recommending the admission or rejection of the application, full stop. It is only after the submission of this report that the adjudicating authority's adjudicatory functions commence under Section 100, full stop.